Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have received some questions, and there has been some discussion in the general community regarding why hasn't Washington State University responded to the lawsuit as of yet, the case that is styled as Steve Goncalves et al. Versus Washington State University. If you were to look at the docket in the Western District of Washington where this case is proceeding, you will see that the complaint's there. It's document number 1 in the filing, but there is no answer. There is no responsive motion, such as a motion to dismiss. The answer to why the responsive pleading or motion has not yet been served, when might it be served, depends on information that we just don't have as the general public right now. We don't know when service of process was effectuated, and that would be when Washington State University was formally served with process, a copy of the complaint and the summons that must be done in every case to satisfy due process requirements. Now, the federal courts operate under the federal rules of civil procedure for basically everything that happens. If it's a matter of a party seeking summary judgment, that's a Rule 56 issue. If it's a matter of requests for productions that a party wants to serve in discovery, Rule 34 will control. Initial disclosures that the parties have to exchange with each other, that's governed by Rule 26. And the answer or the defensive motion that Washington State University will need to file in order to avoid a default against it is governed by 2 separate rules and really depends on whether this is a Rule 12 situation or a Rule 4 situation. What does this mean? The federal rules of civil procedure have 2 rules that address responsive pleadings or defensive motions. Rule 12 says if the plaintiffs served them with service of process, 21 days is the deadline from the date that service of process was actually effectuated by the plaintiffs upon Washington State University. That's Rule 12. 21 days from the date of service. Rule 4 is a rule to try to curtail some of the very high costs of what it is to prosecute or defend a civil action in federal court. According to Rule 4, the plaintiffs have an opportunity to ask the defense if they would be willing to waive formal service of process. And it involves a form that needs to be sent, where there's an agreement that formal service of process will be waived, and then the expense that might be accrued as a result of what it might cost to hire a process server, the time it takes, and there's a deadline that the summons needs to be served. If it's not, then the plaintiff has to go back and get another summons. All of that can be avoided if the defense agrees to waive service of process. And if they do agree to waive service of process, they're given additional time. Under Rule 4, it's 60 days before the responsive pleading defensive motions required to be filed by them. And there's actually a notification from the Office of the Attorney General, Attorney General Nick Brown, service. And it says here, the Washington Attorney General's office will provide a waiver or acknowledgement of personal service of original service of process of a summons and complaint only after actual receipt of the summons and complaint at this following email address. And then it gives the address here. This waiver or acknowledgement of personal service applies only to suits against the state of Washington, its state agencies, and state officials sued in their official capacities. The AGO does not agree to waive original service of process for individually named defendants. The waiver or acknowledgement of personal service is effective the day it is received at the email inbox when it is received on a business day during the business hours of 8 a.m. to 5 p.m. And you can go on to the Attorney General's website to read the rest of that notification. So we see here the AG's office, who has already been filing documents as the attorneys for Washington State University, which is a university of the state of Washington, notified the public at large that this is the process regarding either original service or if agreed to waive service of process. Again, we would need to know when service of process was effectuated and whether there was any agreement of waiver of service in order to be able to determine what is the absolute deadline that Washington State University needs to respond to the complaint in this matter. We're going to continue to keep you posted as further developments arise. Thank you for joining us here today.